Please be seated. We'll hear argument in 2727, Taylor versus Tolbert.
May it please the court, Mr. Daughtry will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you, Chief Justice, and may it please the court. Petitioner asked this court to approach the recognition of common law defenses and immunities from an opt-out perspective as opposed to having to opt in. Texas has been and remains a common law state despite the proliferation of vast numbers of civil statutes over the last few decades. And as this court has noticed in Cash America versus Bennett, the standard would be the legislature writes against this template of common law defenses and immunities, and they're presumed to be ingrained unless expressly excluded or so inconsistent with the statutory scheme that they're meant to be abrogated. And in here, this court has gone through in the Haynes-Boone opinion, talking about the venerable history of what it calls the attorney immunity doctrine. And I'll go even one better with the New Jersey Supreme Court in a few minutes on the federal aspect of this case. But by and large, it is a venerable and important immunity or privilege. And again, I think this court's been very clear and I think appropriate in looking at it, not from the title of what we call this, but a functional transactional approach of what is the lawyer doing? And a very important one, because you can just suddenly plead yourself out of some type of immunity if you don't look into what is the lawyer accused of being doing here.
Let me ask something, because I was a little unclear from reading through all of the documentation. So is there no dispute that what the person who got this information did was illegal?
Well, I'm not prepared. The problem is, this was all done on the pleadings.
Right.
Couldn't really do any, the attorney's in a real hard spot there because at the time, the underlying custody case is still going on, there's representation. Right. So all you can do is without, you can't do any affidavits about, I did this or I didn't do this. We just took the pleadings at their word.
But is there a disagreement that if the facts are as they're alleged, that would be illegal?
By whom? And that sort of begs the question. Illegal, and again, the respect being, there's an interesting question of implied consent in this situation where I'm learning technology along, I used to think I was hip with it, but now with iCloud, if you go sync on somebody's iPad, suddenly it's a conduit.
Well, so for example, let's say in a hypothetical, if somebody is just, doing something, and then all of a sudden this information just pops up, on whatever device they're looking at. They weren't really trying to get it. It just popped up.
Well, there's a statute that's not an intercept. But what here we have is removed from even the claim of intercept. It's an attorney taking information in a custody case that's supposed to be about best interest, when there are also underlying prostitution issues going on and frankly, a CPS reporting obligation. The attorney's handed that by clients. And then what does the attorney do? This is the focus of the pleading. The attorney simply provides this, saying these are going to be my exhibits in a custody case. And this is how it's going to be used. And the functional view of that under Caney Hanger, and I think under Bethel, is that attorney is acting as an attorney in representation. It's not going out and the attorney committing a wiretap, the attorney doing something that is outside of the realm of an attorney acting as an attorney.
But isn't it outside the realm of an attorney acting as an attorney because the statute says that particular evidence cannot be admitted?
Well, actually, there's been a lot of disputes about that.
The type of conduct at issue is saying I'm going to introduce evidence that cannot be introduced.
We don't know that, and that's also there will be fact disputes on how it was obtained and whether the evidentiary bar would matter. But I'll give you an example. Under the federal statute, there's a tiny paucity of federal cases relating to this on wiretap, where one of the cases cited by the respondent said, the court finds that the attorney did not act improperly in presenting materials to the judge on admissibility. Luton versus Devingzo. And also there's some number of cases, lots of disputes here, and this is under the federal wiretap statute upon which the state went.
But this is a summary judgment appeal, right?
No, yes, it's a summary judgment appeal.
If there's a fact issue, then why don't we send it back?
If there's a fact issue, well, it's based upon the pleadings, and the pleadings being taken as true. So we have to live with the allegations that
But you just said there was a fact issue, so I'm trying to understand
if
how
it
that
gets
fits
to the
in.
actual looking at who did what, where, when, and why, and how, and what excuses, there would be fact issues there. Here, based upon simply the allegation is that clients did something, handed the evidence to an attorney, and the attorney, acting as an attorney, offered that and was using that as evidence to be admitted in a custody proceeding regarding the treatment. And we
Which
say
the
that
statute says you can't do.
the statute says in some circumstances you cannot admit evidence that's wrongfully obtained or that it's barred, but it still can be used as impeachment. There's ways to get around it. And there's ways, and again, that sort of begs the question Justice Busby, you asked in the preceding argument, what if they know, but they're not supposed to know? I think is what you said previously in the Fort Worth case that we just heard. And that raises a whole host of things. What are we supposed to do whenever, when someone takes the stand ultimately and says, no, I wasn't doing this, when you know that they hadn't? What about when you have a reporting obligation for Child Protective Services regarding conduct? So that raises a whole history.
Are you saying that a lawyer is categorically immune from any conduct that would otherwise constitute a violation of the wiretap laws?
Yes, I am, as long as the lawyer is acting in that capacity in the course and scope of his representation or her representation of a client here in litigation.
So the underlying facts are just simply not relevant, that they've pleaded that the client manipulated the electronic device to obtain additional information that involved electronic disclosures of more than just the client, but of two people who were not parties to the litigation. None of that should matter because we need a categorical rule here.
Yes, but the factual allegations which are taken as true, you're talking about what the client did, not what the attorney did. And regarding the
Right, but if the client did that and then the attorney either recklessly or with knowledge knows the client did that, then doesn't that bring about a possible violation of the wiretap laws?
I think that the ingrained attorney immunity doctrine would then apply there. Just as if there were allegations of criminal conduct that were alleged in the Bethel case, and this court said, well, it could be alleged to be criminal, but it's in the representation of the client, therefore categorically and from a transactional standpoint, we think that the attorney immunity doctrine would apply there.
But this seems different from Bethel, where you have an additional aspect to the statute that says, attorney, you cannot use this information in this way.
I think not necessarily, and that goes to the remedy regarding that as opposed to civil liability.
I'm not talking about the remedy, though, but the question we ask is, what is the type of conduct at issue? And if the type of conduct at issue, is it foreign to the duty of an attorney or not? And it seems to me that it has to be foreign to the duty of an attorney to threaten to use evidence that the law says you cannot use.
We have a whole book of rules about evidence that can or cannot be used with exceptions, circumstances, opening the door, or regarding impeachment or whatever. And again, some of these federal cases talk about a defense of impeachment. But particularly the Fifth Circuit conflicting with the Fourth Circuit. But regarding the foreign to the duties of the lawyer, I think there's a big difference. The example in Bethel was an attorney destroying, actually affirmatively destroying evidence. I think part and parcel of an attorney's duty representing a client is tendering evidence. And again, we're not saying that there cannot be any consequences. Attorney immunity is a civil immunity. It doesn't evaporate or eviscerate criminal responsibilities or obligations, nor does it take away any obligations or accountability with the trial court imposing punishment or the state bar addressing certain things.
And it's a civil immunity that's a creature of state law, so can it be a defense to the federal claim here? I
think so, and it's not necessarily just Texas has its own, but Haynes and Boone decision talked about how it comes from British origin and how it had gone so far. And we're asking the court to do just what the New Jersey Supreme Court did in Loigman versus Township Committee of Middleton. I'm doing a little brief, but 889 Atlantic 2nd 426, where it went further and talked about how this doctrine went all the way back into medieval times, talked about colonial applications of it, talked about obviously the same House of Lords provisions, and that it was pervasive. And the decision there by the New Jersey Supreme Court, which for which there was no writ of certiorari granted, and it's not been reviewed since, said, we cannot believe that the Congress would sit there and write something and with such a prevalent doctrine of attorney immunity and have intended to eviscerate it.
But you acknowledge it is a federal question.
Absolutely, yes. I can't get around it, yes.
And
On the
so
Federal Wiretap
question
statute, yes.
Is how do we supply the substance? Is it necessarily true that the attorney immunity doctrine that Congress would have had in mind when passing this statute is the exact same one that we, as the Supreme Court of Texas in 2021, are going to identify?
It seems to be that it's general, but again, I will concede different states have different views of it. And again, that comes down
It isn't really
to...
about different states having different views. It's a question of what is the substance of the federal defense. And so there are some cases, I mean, you've got the Clearfield Trust Company case that says, well, it's a matter of federal common law, even though it's commercial law, and we're going to have a uniform federal rule, even though all states have their own rules about whether or not something is timely when you're presenting commercial paper. Or there's the Kimball Foods case in which they say, yes, it's a question of federal common law, but we're just going to borrow from whatever state it comes from in the U.C. context at issue there. I don't know how to choose which one it is, but I'm not confident that just because it's in a Texas state court that Congress would have said, yes, we want the Texas version of this to apply.
I understand that very well, and there's a paucity of decisions on it. I just know that it is something that has been well accepted, that there is a recognized federal root and understanding of attorney immunity. They call it litigation privilege. But when you type in litigation privilege in Westlaw, you get about 3,000 results, and then what you get are just a couple of, just a few handful of decisions talking about it that really provide no great input if you look in the cases listed.
If you go back to Texas law and the Bethel case, where we declined to say that we would recognize a per se criminal conduct exception to the attorney immunity doctrine, are you asking us to hold that any conduct alleged to be criminal is still cloaked with immunity so long as whatever that conduct is involves presenting it in court?
I can't answer the question that way because I think it's a little circular, Your Honor. In Bethel, it said we're not going to do a per se. We're going to look at, are you acting as an attorney? And and clearly here, this is within the scope of attorney-client representation and advocacy with the court to raise these issues.
So what if the lawyer, maybe this is an easy one or maybe not, what if the lawyer breaks into the house and steals the documents and then presents them to court?
Well, then clearly, then that's not within. Just as there's one of the cases where
so it's
a
the
lawyer
fact
would
that-
have done the actual wiretapping himself or herself.
Okay, so it's
Yeah.
the fact that it was got from the client that you would say makes the difference.
Presenting it to a court.
What if the
Taking
lawyer
evidence, but
asks the client to go do that?
That's a tougher call. In one of the cases, one of the federal cases, actually mentions that there was no advice or solicitation. It was just the lawyer providing evidence had been provided to the client.
What
There's
about
no,
the lawyer and facilitating sending it to the expert consultant in this case, the forensic expert that settled?
yes, there were instances that's how it was pulled, and then later it was done pursuant to a court order, which I think cloak it with immunity there. But yes, having it harvested by an expert, again, that's something that part and parcel of what attorneys do to go. I can't tell you many times, especially in family cases, you're going and you're harvesting somebody's emails and computers and hard drives. You don't know what's there necessarily, but then the expert goes and pulls that and categorizes it. So I still think that falls within the functional transactional standard of, are you acting as a lawyer, gathering evidence or dealing with evidence given to you by your client. But again, Mr. Blacklock, Justice Blacklock, I would say I agree with you that if a lawyer's going out and manufacturing wiretapped evidence, the lawyer's doing it, him or herself, I think that's beyond the bounds. And that shifts over to the continuum line of, like was said in Bethel, like I'm destroying evidence.
So asking the client to do it, that might not be protected, but
Certainly
sort of
the lawyer.
letting the client do it, knowing the client's doing it, and then sort of taking that, knowing where it came from, is protected.
I don't know that what's before this court based upon the allegation. There was no allegation that the lawyer participated, instructed, solicited, advised, or whatever. Simply the allegations that are coming here on the pleadings are that the lawyer was given it and then provided it intent to use as evidence.
Is there an allegation that the lawyer knew that it was ill-gotten?
I believe there's an allegation sufficient to create an issue that the lawyer might have known that it was not kosher.
At the level of generality that some of the cases have been at, why would it be different for the lawyer to instruct? I mean, lawyers instruct clients to gather relevant evidence all the time. The fact that this one is illegal in violation of state and federal law might seem bad, but if we're looking at this highly generalized inquiry, why would that be on the other side of that line?
I still think that it's something someone can gather and use. And then what happens if you find out the worst of it is that it's something that has to be reported regarding child abuse or endangerment of a child. But I agree with you in the continuum. I would argue that even instructing or soliciting, as unsavory as it is, would be still within, I would call the categorical Kenny or Bethel view of what a lawyer is doing in the representation of his client in litigation.
Does that lead to a reductio ad absurdum that should make us wonder if that highly generalized approach really is right?
No, I think that is, of course, the court looks at these on a case-by-case basis regarding what the allegations are. And here it's a little bit more rigid because we're not, we're on an accepted pleading. I think that the way Bethel's done it, otherwise the opposite is an equally or more so rigid approach where I can plead myself out of attorney immunity by artful pleading and characterization and certain things that just don't apply.
Any other questions? Thank you, counsel. We'll hear from the respondents.
May it please the court, Mr. Enos and Ms. Robbins will present argument for the respondents. Mr. Enos will open with the first 16 minutes.
May it please the court. It appears I only get here every 25 years, so I just want to say this. It is an honor and privilege to be here in this temple of justice, and it's an honor and privilege to do what I do for a living every day, the grimy, nasty work of being a divorce and child custody lawyer. I represent Carl Tolbert and Nazira Kimball, two people who were not part of the underlying child custody case, two of hundreds of people whose communications were intercepted during a 7-month period when the opposition in her custody case was receiving in real time her messages. 7 months during which she was a litigant in a case against him and he had access to all her messages. So this case goes to the heart of what we as lawyers do, and this attorney immunity defense goes to the heart of what we want lawyers to do. And so one point I want to make very clear is, unlike Bethel, where the brakes somehow got altered in the testing, which seems unlikely to happen very often, this situation happens all the time. Emotional, angry, upset clients come to divorce lawyers with evidence that we have to ask them, where did you get this from? Whose password is on that computer? Us lawyers in my realm constantly have to protect the clients from themselves and find out how they got the evidence and make an assessment of whether it's legal or not. And sometimes we have to say, look, you take that back, I'm not having it. I can't be your lawyer. You need to go see a criminal lawyer.
Where's your authority for that? That the attorney has the responsibility themselves to, once they're understand that it's reckless, is that if they don't do that because of the information that was presented? Is that what you're saying?
Yes, ma'am. And so the reason I'm bringing this up is the whole rationale for the attorney immunity defense is we want lawyers to do right by their client. We want them to be zealous advocates. But we also want them to protect the client sometimes. And taking away the attorney's liability takes away the attorney's incentive to do that. So,
isn't there still professional discipline and criminal prosecution? I mean, aren't those things that an attorney might be thinking about when he refuses to use unlawful evidence and not just a civil suit?
yes, in theory, although the odds of the state bar or your local busy, overwhelmed DA actually doing anything about it are pretty slim. But what really happens is when the client brings you that stuff, you don't think about yourself first. You're thinking about the client and the case and what the judge would think and whether the evidence is admissible or not.
If this had been a home computer and the same thing happened, downloaded 7 months of communication on a home computer, that no one argues that, everyone had access to. Is the lawyer still in trouble for producing information gleaned from that home computer in the litigation?
There's plenty of circumstances where a husband and wife share a computer and getting information of it is not illegal. And so if in the scenario as I hear what you're saying, it probably wouldn't be, because we do that kind of evidence gets used all the time. But and
could
again,
someone then say, oh, you illegally intercepted these communications, even though they were available to the party because they were on a home computer, and sue the lawyer on the other side and use that as an advantage in the litigation to try to remove the lawyer or keep the evidence out?
and that shouldn't happen, and we don't want that to happen. And I'm not saying I have all the 100% precise answers, but the trouble is we're only going by my petition. That's the only facts. And fortunately for me, this petition was a lot more detailed than they typically are. But the only facts we have to base this decision on is the aunt in Austin, her iPads after the child visited suddenly started getting her messages. And then the aunt sent it to, who was a lawyer, sent it to her brother who was in the custody case with her. And for 7 months, the brother could see in real time what she was sending to people and what she was getting from people. So the rationale for the attorney immunity is that we want attorneys to be zealous advocates. And that's been the rationale since at least 1606, the earliest English case on this subject. But for the first hundreds of years of this, it was called litigation privilege because it meant they couldn't sue me for what I said in final argument. Okay? It's really only very recently that courts have begun to say it's not just the words I speak or write as a lawyer, it's the actions I take. And that goes back to a question I heard earlier. In 1968, when the Federal Wiretap Act was enacted, in 1981, when Texas enacted the State Wiretap Act, the litigation privilege was largely what it had been for hundreds of years. You can't sue for defamation. When Congress expanded the Federal Wiretap Act to include electronic communications in '86, there still weren't cases like we have now in this state that say anything the attorney does while they're representing the client is privileged. So you can't say that the legislature and Congress took the 2022 version of attorney immunity and thought that's what we're applying for. And I heard a question in the earlier arguments, and I was so glad I was here to watch those. I heard a justice say, well, where does it say that in the statute? And that seems very important to y'all. Where does the statute say that? Well, in this case, the legislature wrote a statute making things illegal, has certain defenses, but it didn't add the defense of being an attorney. Congress passed a statute and then rewrote it and never added the defense of an attorney getting you out of civil liability. So if you're going to, in all these other cases, say, what does the statute say? I would point out that in this case, the statute just doesn't say that.
Well, but our general rule is that if we abrogate a defense, it's got to be clear that that was intended, right?
I agree. And you can go back through, I wouldn't recommend it, but you can go back through what records exist from 1981 when the Texas legislature enacted this law, and they weren't talking about this kind of stuff. They were trying to protect citizens' privacy. And although I don't want lawyers to get sued very often, I have a selfish interest in that, and I don't want it used for litigation advantage, that's wrong. But I want my privacy protected, and I want his privacy protected, and that's something that you all have to balance. But in this case, what makes this case different than all your other cases on this subject is, unusually, the legislature and Congress have said this behavior is a crime. You can't use anything you get from it as evidence, and you can sue the person civilly. There's very few other examples in Texas where it's both a crime and the legislature, as part of that law, gives you a civil remedy. That's what makes this very different. And so the rationale of we want attorneys to be zealous advocates, which is the reason why you have attorney immunity, doesn't apply in this situation. We do want attorneys to be zealous advocates, but if the evidence, again, we have to go by my petition and assume it was illegally obtained. If the evidence was illegally obtained and I can't use it, and I know I can't use it, how am I being a zealous advocate? How am I promoting that?
If the lawyer doesn't think it was illegally obtained, then what?
Well, and
He
that's,
asks the client, did you obtain this illegally? And the client says, not surprisingly, no.
And-
So he's going to cross-examine the client?
I don't know, at least in my practice, I don't always believe 100% of what my clients tell me. I have to check
Well,
and
I
verify
understand that,
things.
but do you want to know?
Well, in this particular subject, part of you says, I don't want to know, but part of you, if you're going to serve your client, does want to know, because just because they tell you that now, 3 months later, when it turns out the wife finds the recording above the recording device above the refrigerator, you do want to know. And that's what, I'm going to go back. In this situation, the client's interest and the attorney's interest are the same. If it's potentially illegally obtained electronic communications, I want to know that as soon as I can and not use it and protect my client from it. And again,
So if the client says, no, it was not illegally obtained, what is the lawyer supposed to do at that point?
well, it would depend. If it's a recording of the wife talking to someone on the phone, I would still ask, well, how did you get the recording of the wife talking on the phone? It's going to depend. I mean, what we usually get is text messages and emails, which is what this case is about. There are other ways, of course, of getting that, but generally speaking, but even then, this case that's here before you isn't someone brought some printouts of an email. They had an iPad that in real time was showing the communications of this lady. As she got an email, so did the aunt's iPad. So in this situation, the actual thing you had in your hand should have told anyone, this can't be right. I can't have this and get her communications. The litigant in a case who for 4 months was pro se and for 2.5 months had a lawyer. For 2.5 months, she had a lawyer and everything she sent and received was seen by the other side.
But
So-
remember, we have to craft a rule that would be applied to a lot of different situations.
Here's the rule I would propose, and it's very narrow, and that is, if the legislature creates a law that makes behavior illegal a crime and provides a civil remedy, then you can sue everyone, including attorneys, unless the legislature exempts attorneys. That's a very narrowly crafted rule that would just apply to very few cases. And frankly, again, I'm not sure there are any other statutes in Texas that are like this, where you have criminal liability and civil liability all in the same statute.
Is it even narrower if you add to that that the legislature has told the attorney, don't use this information in this way?
Yes, and yes, that would, but that would take, there are other situations I'd imagine you can't, I can be liable for my kid trashing a hotel. That's a crime, but I can also be sued for it. That's the only example in Texas where I was able to find that they have a crime and a civil liability all in the same statute, and evidence isn't an issue there. But that's what makes this case unique. The other thing I want to emphasize in the time I have left is, from the very beginning, this immunity has had the exception of, is it foreign to the duties of an attorney? And I think it would come as a shock to every lawyer in Texas if you tell us that committing a crime, committing a federal crime, is not foreign to the duties of an attorney. So in the Bethel case, they sued for common law torts like conversion. They didn't allege a crime. It wasn't until it got to the appellate level that they said this is criminal and there's a criminal exception to attorney immunity. But there was no specific crime that was alleged. I don't know what it would be, destruction of personal property or something. But Bethel was different because they sued the attorney for trespass to chattel and conversion. They didn't sue under a criminal statute that also allowed civil liability, and that's what we have here. And there, this court said, well, if the attorney took a sledgehammer and smashed the brakes, I think you could sue him, okay? Well, why would that be? That would be an intentional knowing act and a crime. And that's exactly what we have here. I mean, our suit alleges knowing violation of a crime.
I think that the opposing party is agreeing with you on that point, right?
Okay. Well, and so I think it's possible to uphold the dignity of what we do as lawyers and say that you expect us not to commit crimes, to carve out a very narrow exception to the general rule that won't affect 99.99% of other situations, and still allow people to have the remedy that the legislature gave them, and still act to protect clients and the public's privacy, and give us that incentive to do so.
The federal point, assuming that we don't agree that that attorney immunity doesn't apply at all, how are we supposed to choose the rule of decision for what the content of attorney immunity is federal as opposed to state?
Well, it's not clear to me that this court does have the power to graft this common law defense onto a federal statute. The wiretap litigation, there was a lot of reported cases when those laws were first passed, but none of them involve common law defenses to the Wiretap Acts. They all involve, can a state have a more stricter wiretap law than the feds? The case law seems to be that Congress said it was okay for states to have a stricter rule, but not a laxer rule.
Set aside what the state one is. If we just have a federal claim under the federal statute that's brought in Texas court, you agree that it's a federal question whether or not there is this defense?
I totally believe it is.
So we're not able to just make it up in the same way that we, in theory, at least would have the power to do so under Texas law. So we have to figure out what it is that Congress and the U.S. Supreme Court would say. Right. What do you advise for that? Again, assuming that we've gotten past the idea that it doesn't exist at all.
Well, I would say the question I heard earlier, what's in the statute? In Section 1983 lawsuits, we look back to 1871 to see what the status of immunity was in 1871. All I could say is, if you're inclined to do that, you would want to look back in 1968 and see what the status of the attorney litigation privilege was then. And I am very confident you will find it was essentially limited to defamation and slander cases. It had not been applied to statutory causes of action and had not been applied to the kinds of acts that you've had to deal with in the last decade.
Do the cases show whether or not, if there is a federal claim brought in different states, whether federal court or state courts, that the content, whenever attorney immunity is applied, that it will vary from state to state, or is it a uniform general common law type of defense that would apply the same in every?
It seems like it's every state. So, for example, Florida has gone as far as this court has gone on attorney immunity, where any action of an attorney representing a client is immune. Other states like Colorado are still back with it's just defamation and slander. So I would assume if this exact same scenario happened in Colorado, there'd be no doubt we could sue them. In Florida, maybe you couldn't. And that's yet another problem, and I'm sure that's not what Congress meant. And I think Congress enacted the original Wiretap Act in 1968 in response to Supreme Court decisions to have a uniform law all across the state, all across the United States.
You can imagine a scenario in which you win under your federal claim but lose under your state claim.
No, I really don't, because I don't think this court is going to say that committing a crime is part of the duties of an attorney. It's just foreign, that is foreign to what we do. And in this unique instance, I don't see how you could do that. But if you did, I still don't think this court has the power to rewrite what Congress clearly meant to do in the Federal Wiretap Act.
Any other questions? Thank you, Mr. Enos.
Thank you. It's been
Ms.
an honor.
Robbins, we'll hear from you.
I want to thank this court today for recognizing me as pro se counsel. As pro se counsel in the underlying custody battle, I was considered opposing counsel. And I don't know a lot of statute. I just know what's fundamentally wrong and illegal. This isn't a case about what happened surrounding improper discovery, disclosure, and production. For me, it's not. Because the crimes that were committed by Ms. Taylor occurred before discovery even commenced. You've all been practicing attorneys before. Imagine for a second the perversion of the justice system if all your emotions were immediately countered, but you didn't know why. Your work product was shared and known. Your strategy was shared and known. Your planned line of questioning of witnesses that were yet to be called were known. Your whereabouts at all times were known. Your private conversations with others about you, your case, not about your case, were known by opposing counsel. Your ideas, all your thoughts about your case were known by opposing counsel. All of this occurred when I had no attorney, and I was actively acting as my own attorney in my case for months, filing many, many motions and having many, many hearings before the court. All of these things were known by opposing counsel and were used to her advantage to get one over on me every chance she could. I didn't have to imagine it because I lived it. It happened to me as counsel in my own custody battle. Communications I had with witnesses before a hearing were known by opposing counsel. While they were out in the hallway and I was texting them, they were known before a docket was even called. As pro se, I'm afforded the same rights, protections, and privileges as an attorney would be. And I was bound by the duties as well. Any opportunity that opposing counsel had to get me on not following the rules of Texas procedure, of civil procedure, I got it. But yet, I wasn't afforded the privacy of counsel against my opposing counsel in the case. Petitioner's actions were so poisonous to the trial court that not only were my constitutional rights violated, the rules this very court sets for all participants in a court of law were ignored and poisoned. That trickled down to rob all of the other players and their commitment to their duties. The judge robbed of their duties, robbed of their ethics and commitment to those canons that you hold so dear. They were robbed of that. After 4.5 months, I couldn't understand how opposing counsel always seemed to get the upper hand on me. I finally hired an attorney, but the interception continued another 2 months with him on board, and attorney-client privilege was then compromised. What's the standard this court is going to hold petitioner to? There were many victims, but the smallest and most vulnerable was Natalie Renee Broom, my daughter. At the end of it all, I walked away with primary custody of my child. Even though petitioner attempted to blackmail me and shame me, just as her attorney tried to do today already. Tried to shame me and blackmail me into giving up my fight, but I never did. I fought and I fought because it was fundamentally wrong for everything that we hold dear in the United States of America, what this attorney did and how she used these improper communications to gain unfair advantage in this custody case every chance she could. I believe all things happen for a reason, because everything that transpired and how my daughter's life was changed. She's graduating in a few short months from college. From University of Virginia in the Distinguished Major Program of Philosophy, Policy, and Law, she was changed. And although me standing here today and telling you my personal story of how I was impacted, I hope one day she'll be before this court announcing her name out loud in person to advocate for change to the attorney immunity rule.
Your time has expired, Ms. Robbins, if you could conclude.
I'm sorry.
Go ahead and conclude, your time has expired.
I ask you, the court, to affirm the decision of the Court of Appeals on this matter. Thank you.
Mr. Daughtry, you have 5 minutes.
Thanks, and I will try to answer some questions as fast as I can. Justice Busby, the example you gave regarding prohibitions on use of evidence, somehow conflicting and meaning that there's no attorney-client, there's no attorney immunity there. That statute directs that governments and prosecutors cannot use evidence and admit it. Would that somehow impair then, in your rationale, the common law imposition of sovereign immunity? Because it's a common law defense. I think it shows that it shouldn't work that way. Secondly, Chief Justice, you asked about, interviewing the client or deposing the client. The real question and the real problem is, even worse, you're going to cross-examine the lawyer who has an unwaived attorney-client communication privilege. So the lawyer could sit there and say, I didn't know, or I wasn't told this, or I was misrepresented to this. Puts the lawyer in a real bind, which is why we have, Justice Bland, this categorical view of the functionality of how you're acting as a lawyer if it's within that scope.
But the statute in this case is a little bit different, right? Because it makes criminal conduct the interception of the electronic communication itself, and then also provides liability for using that communication either knowingly or recklessly.
Sure does.
So
And if
it's different than simply advancing your client's interests and the client's done something wrong. There's liability imposed for the use.
well,
So how do we?
Bethel involved an allegation that the court had to take that way is criminal conduct being used for the betterment or advocacy of the client. And here, it goes to civil liability. It's not some type of wholesale bar on criminal liability. So it, ultimately on use goes to civil liability. And it begs the question, how are we going to determine that? By having a client who cannot, having a lawyer who cannot waive privilege? And again, in answer to your question, Justice Young.
But regardless of what the underlying conduct was, there's independent liability for use.
Well, if it's used based upon that, yes, but what did you know? There's questions of knowledge and things like that, where an attorney in the situation can't defend herself. And then Justice Young, in terms of federal, yes. It is a federal question, it is a federal determination, and it's not just simply what Texas says or what Ohio says in some of these cases. I will just tell you that it's not clear. As a starting point of how the court should approach it, I would suggest looking at the Loigman case that I mentioned, and I'll follow up with the letter brief. But fundamentally, what we have here is an allegation that, what is the lawyer to do in this situation? There was an amicus pre-filed, and I think that's pretty poignant on that situation. The lawyer can't sit there and provide an affidavit saying, I didn't do this, I didn't do that, that's not how it went down. You might be surprised to find out that this particular lawyer didn't do some of the things that are in the petition. We're sort of stuck with it. And all those things may come up, but what is the lawyer to do when faced with evidence given by a client saying, defend me? And how do you get to the answer about whether it's right, wrong, indifferent, or necessary? And then the other thing is, and it's a great example, because when I first stepped in to defend Attorney Taylor, I was in a hearing and counsel just put, I knew that there were claims against her, criminal claims, criminal allegations against her, put it in, hey, look at this if you dare. Well, I haven't looked at what those communications or things are. We only have, and this court only has what's said in the petition. I don't know what's in there and what's not in there. And why? Because I'm afraid that if I do that and look at it to defend my own client, that I may have the same type of liability, even though I'm looking and using something to defend my client from her own claim of civil liability. Where does it end? And I don't think the court would doubt that whenever I'm looking at to try to defend her, to figure out how to defend her, am I acting in the course and scope as a lawyer? But if I use that evidence, am I using it under the statute? These are all problems. And yes, statute.
If a criminal defense attorney was representing somebody who's been charged with child pornography, and the defense lawyer is using whatever underlying photographs or whatever there was in the case, you would argue that if we don't do something here in terms of immunity, that lawyer would not be protected.
I'll give you an example.
Using
That
information in the course of the criminal defense.
That very example, there's a defense and there's a statute for criminal liability, but the same conduct that's being alleged by the lawyer, I think it's chapter 21 in the Penal Code, which has blended civil and criminal liability for looking or sharing or using pornographic images or things that are videotaped. So without the impression of attorney immunity, attorneys doing their job could be put at risk. And again, we talk about, well, no statute says this. It's an opt. It's never an opt-in. It's always an opt-out. We have all the time statutes that are imbued with these common law defenses. And again, I think sovereign immunity is the classic example because none of these statutes hardly ever mention sovereign immunity. But again, as a matter of common law, it applies. And again, Owens, I cited in the brief, that's U.S. Supreme Court talking about this ingrained common law defense. And it has tons and tons of different types of defenses and immunities that are accepted, but were not written into that statute. I see my time's up.
Any other questions? Thank you, counsel. The case is submitted, and that concludes the arguments, and the case is set for this morning. Marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.